Hello all, welcome to Legal Talks by Desi Kanun. I am Suyash and I am excited to have started this show. On today's show, we will talk about another case that has been decided by the Honorable Supreme Court of India in relation to COVID-19 pandemic. In this case, the Supreme Court discusses the question in relation to pasting of posters on the houses of COVID-19 patients in India. We are very familiar with the COVID 19 pandemic as all of us are living in it, and we might have heard about many instances where posters have been pasted on houses of COVID 19 patients by the municipal authorities or the governmental authorities. So let us discuss the case at hand. The name of the case is Kush Kalra versus Union of India and others. It was a public interest litigation filed under Article 32 of the Constitution of India, and the court pronounced its judgment on 9th of December 2020. In this case, the petitioner questioned the decision taken by the various states and union territories to affix posters outside the residences of persons who have been tested COVID-19 positive and are required to undergo home isolation. And many arguments in this regard were advanced by the petitioner. The petitioner contended that people have a right to live with dignity, and if posters are pasted outside the homes of COVID 19 patients, then it is a serious violation of their fundamental right under Article 21 of right to live with dignity, as there is a reasonable likelihood that such persons would be judged by the society. The prayer sought by the petitioner was for issuance of directions to stop publishing the names of COVID 19 positive persons by the officials of the states and the union territories. And the petitioner further prayed to stop freely circulating their names in welfare associations of colonies and apartment complexes, as the same constitutes serious violation of their fundamental right, namely right to privacy and right to live with dignity. The court heard all the parties. In this case, the arguments were advanced by the petitioner and the Union of India. And the court asked the Union of India to provide all the guidelines that it issues in relation to pasting of posters or in relation to COVID-19 pandemic. The Union of India submitted its reply, and after perusing those replies, after hearing all the concerned parties, the court observed that the Union of India has not issued any guidelines for pasting or affixing of posters or other signage outside the residence or houses of COVID 19 positive persons. And it was also observed by the court that the guidelines pertaining to COVID 19 are referable to exercise of powers under the Disaster Management Act 2005, and the same do not contain any requirement of pasting of posters against the houses of COVID 19 patients. All of us know that all these lockdowns, all this process of unlock, all the guidelines relating to the management of COVID-19 pandemic are issued under the Disaster Management Act, since it is the competent law that provides for management of any disaster of this magnitude. So, in view of the arguments that we have discussed earlier, it was finally observed by the court that no state or union territory is required to paste posters outside the residence of COVID 19 positive persons as of now. Here, what is important to note is the usage of the words as of now. The court clearly stated that since the Union of India has not issued any guidelines in this regard, and it is the foremost and the competent body to issue guidelines in this direction, and since it has not done so, thus no state or union territory is required to paste posters as well. And further, the court very unequivocally held that the state governments and union governments can resort to the exercise of pasting posters against the houses of COVID 19 patients only when any such direction is issued in this regard under the Disaster Management Act 2005. Thus, it left this question open whether pasting posters could be carried out at a later stage by the states or union territories or not is a question that has to be decided under the Disaster Management Act 2005. Now, what is our analysis of this case? I find the final observations of the court to be quite interesting because, on the one hand, the court made it amply clear that currently there is no requirement of pasting posters against the houses of the COVID-19 patients. And on the other hand, the court did not close that option or did not hold the pasting of posters to be a violation of fundamental rights per se. Thus, the questions whether posters could be affixed or not, or are required to be affixed or not in the future, has been left wide open, as I stated earlier. And in a way, the court refused to exercise its jurisdiction to go into this question. It is at best an academic question as of now, according to the Supreme Court, because the Disaster Management Act 2005 and the guidelines issued under it do not provide for the same. If the COVID-19 pandemic gains space again, or if the number of cases again rise, then it would be for the competent people to look into this question. And another important thing that we must understand that the Disaster Management Act 2005 is the competent law that the union government is exercising to make endeavors to manage the COVID-19 pandemic. And everything in this relation is being handled by the union government only. And whatever guidelines the union government gives, those guidelines percolate to the states and the union territories. In my humble opinion, I think the methodology of the court is quite apt, and when something has not been provided under any statute or under a competent law, that is the Disaster Management Act 2005, then such question should be left open for the executive to decide as and when the need arises. The question of pasting of posters against the houses of COVID-19 patients, whether it is required at a later stage or not, is not necessary to be examined right now. And as I stated earlier, the court knows that the COVID-19 pandemic is a very serious hazard, and it is not only a health hazard, but it affects our lives in unimaginable ways. Thus, the court acknowledged that it is not an expert on COVID-19 pandemic, and it left its manner of management to be decided by the experts and competent authorities. So thank you for watching this short episode. I hope you enjoyed it, and please subscribe and follow us on YouTube, Instagram, iTunes, Twitter, LinkedIn, Discord, Telegram and Facebook. Thank you again. Stay tuned.